Hi, this is the Telecommunications and Information Revolution. I'm James Goodale, the host. This show is co-produced by New York Law School and Jake Trobe. And I'm here today with Ken Norwick, who is representing the ACLU in what I would call the Robin Byrd and Maletta case. That's not quite correct, but the case that Ken has the very same issue, isn't this right, Ken, that a case that was recently argued in the Supreme Court and in fact may be decided by the time people see this show, which raises the question whether the Helms Amendment is constitutional. And the Helms Amendment is complicated, but very simply put, it regulates indecency on cable television. Wouldn't you say that's generally correct?
Well, no, it regulates indecency on two categories of cable television: least access cable television and public access cable television. It very conspicuously has nothing to say about indecency everywhere else on the cable. And as we know, most cable systems have channels dedicated to indecency where they make a lot of money, and that is not of any concern to Senator Helms. It's only programming that the cable system doesn't make any money from. That seems to be the concern.
And that's known as, we'll call it access programming,
access,
okay?
right.
And the way access programming works is that the government, city government or the federal government, mandates Time Warner to make its channels available for Lou Maletta and Robin Byrd. And they make a deal with Time Warner whereby their programming can come on to Time Warner. And I don't think it's any secret that Time Warner doesn't want that programming. Isn't that correct?
Time Warner doesn't want any least access or public access programming. They certainly don't like Maletta and Byrd and Al Goldstein, but they don't want to have to run anything that they can't control and that they can't maximize profit from. Their view is that they are a private enterprise, they're a profit-making business, and they should not have to carry anything that they don't choose to carry. That's their view. That's not the Congress's view. It has not been the court's view.
But aren't they right?
No, of course not. I mean, they're dead wrong. What the cable systems like to believe is that they're just like a newspaper. And if you're going to start a newspaper, if you buy a printing press and a copying machine, you can be a newspaper. And everyone agrees that the government cannot tell that newspaper that you must carry Robin Byrd, or you must carry the sports section, or you must carry the religious section, or the Pat Buchanan page. No government can tell a newspaper or a magazine what to publish. That's clear. Cable is entirely different. Cable cannot simply open up shop and call themselves a cable system. Cable has to go to the city government and say, we would like to chop up your streets. We would like to run our wires across your airspace. We need you, City of New York, to allow us to do this so that we can make money. Well, the City of New York says, if you want to cut up our streets and mess up our sidewalks and everything else, and you need our permission and you need our blessing, guess what? We're going to negotiate with you. And we're going to make you pay a franchise fee. And we're going to make you do a few other things, like make space available for people who can't be on the cable anyplace else.
But and you're going to take my First Amendment rights away.
Sir.
I'm the cable company, and I want, you use the word control.
Right.
Why not? I want to control this program. Why can't Time Warner control all its programming? It's a publisher.
Because your premise is wrong. They don't have a First Amendment right.
They don't have a First Amendment right?
To get a franchise?
Sure, why not?
They can go to court and force the City of New York.
Why not?
On what terms? For free?
No, but if I want to speak, here I've got
Right.
I want to speak, I can go anywhere I want on my little cable. I'm a First Amendment speaker.
No, your
Why
cable,
shouldn't I be able to do that?
doesn't reach anybody until you cut up the streets of New York.
Oh, so it's cutting up the streets the important part? So if you cut up, so the rule's got to be if you cut up the streets, I have to give away my First Amendment rights.
If you want to make a deal with the City of New York,
Well, make a deal.
if you want the permission of the City of New York, you have to agree to the terms, just like you have to pay a franchise fee. You know what the cable system also argue? Even paying the city a franchise fee
Right.
is a violation of their constitutional
Well,
rights.
I want, never mind the friend. I'm just talking about
it's the
Robin.
same point.
All I want to talk about is Robin Byrd. And would you concede I've got no First Amendment right whatsoever?
You as the cable system?
Yeah. When I open my mouth, speaking as a cable operator, I don't have a First Amendment right?
No. We are talking about least access and public access.
Yes.
We are talking about a small fraction of your channels. Time Warner now has 75 or 80 channels, and the limit can go to hundreds and hundreds of channels. Congress of the United States, signed by the President, and so far upheld by all the courts that have heard this, said, yes, you can have a cable system, and you can speak, you can be a speaker, except we're going to authorize a tiny set-aside, 10% of your channels for people who couldn't be on television any other way. People from the community, ethnic groups, sexual minority groups, racial minority groups, that all want to have their say. They want to reach an audience. We, the Congress, and we, the courts, think it's okay, as part of the deal with the franchising entity, the city, to say, set aside a couple of channels for people like Robin Byrd. On those channels, you have no First Amendment rights. Because you've set them aside. You've become, like the phone company, you've become a conduit.
Now, when this case was argued before the Supreme Court, Justice Breyer, whom we think probably will be a good First Amendment justice, we don't know yet, but we think he will be, said, I'm very troubled by this case because I have, and he could have said Robin Byrd, on the one hand, who wants to speak, and on the other hand, I've got the cable company who also has certain speech rights. So he said, effectively, we have a case where we've got a conflict of First Amendment rights. First Amendment right of the cable company wanting to control its channels so that it can make a presentation to the public, not unlike a newspaper, and the First Amendment rights of Robin Byrd. Will you not concede there's a First Amendment conflict here?
No, there's not a direct conflict, but yes, the cable systems have First Amendment rights on the channels they control. Everyone agrees on that. You will know, you more than most people know that there's a much greater intrusion that Congress came up with, far greater than least access and public access. Congress decided that cable systems like Time Warner must broadcast for free all the local broadcast channels. In New York, there must be 8 or 9 of them. They have to set aside as much as 1/3 of all their channels for what we in the business called must carry. The cable industry went to the Supreme Court 2 years ago and said, we have First Amendment rights.
They lost
you
that
can't make us...
Well, just because they lose that one doesn't mean they're going to lose all of them.
But the Supreme Court said, but you asked about the clash of First Amendment rights. The Supreme Court said, yes, as a cable system you have rights, but they're not absolute rights. And they have to be analyzed in terms of the medium you're in, the business you're in. And we think, given that you are effectively a monopoly, and you are a monopoly bestowed by the city is going to make you a monopoly so you can make gazillion dollars here. We think because you're a monopoly, because you will control what people can watch on television, it's okay to make you carry the local NBC and the local CBS. If that's okay, then I guarantee you it's okay for the far fewer channels that are least access and public access.
Ken, as an ACLU lawyer, you know that the ACLU for decades has been trying to level the playing field as it sees it in terms of powerful media interests, call them monopoly interests or not, and the minority speaker, and has created this whole theory of access. And that's what the Robin Byrd case is about, whether she can use public access as she wants to, or whether the cable operator can come in and make her do it the cable operator's way.
Well,
this has been going on. It's just another example of this.
Yeah, but remember that we're talking about communication media that require government blessing, government licensing,
Right.
We're not talking about newspapers, and we are not talking about magazines, and we're not talking about leaflets, and we're not talking about people standing on soapboxes. We are talking about the broadcast media, which require licenses from the government, and we're talking about cable, which requires a franchise from the government. When you go to the government and say, I want a scarce channel for my broadcasting, or I want to have an effective monopoly on cable, is it okay under those circumstances for the government to set aside some channels for people who can't be heard any other way?
Okay, now what happens with the internet? Is the ACL's theory the same, that you have to have access? How would you do that,
Well,
by
you
the way?
can't. You see, the beauty of the internet is that everybody can be on. Everybody becomes a Robin Byrd. Everybody becomes a speaker. You just have to have a home page or a site, and you're out there. And what's happening now, of course, is the government's going to try to clamp down.
And that's why this case is so important, by the way.
This case is important because it's going to address this notion of indecency. We've always had laws against obscenity. Now, the ACLU believes, I believe, that we shouldn't, the First Amendment doesn't even permit obscenity laws. The government should not be telling people that this is not good enough or not appropriate, and we're going to send you to jail because you have two people who are nude, or two people touching each other, or two people having sex, or 3 or 4 or 6, or however many people the producer wants to show. Our view is speech should be permitted without the heavy thumb of the government on it. Let the viewer choose. We have so much other garbage that's out there already. We have so much violence that's out there already. We have hate speech. We have Nazis. We have all kinds of people that Congress and the courts have said they have a right to speak. Only when it comes to sex, the most basic, the most universal phenomenon that we all know, does our government get so uptight that they want to send people to jail for showing sex on television, not for killings and not for maimings and not for hate speech and not for bigotry, but only sex. Well, it's silly. It really is, Jim.
Well, it may be silly, but we do have obscenity laws.
And
the obscenity laws are enforced.
Or not.
Or not, but
Right.
they can be enforced constitutionally despite what the ACLU says with respect to obscene speech. Isn't that correct?
There are obscenity laws. They're supposedly limited to the most, quote, hardcore of pornography. There's a 3-part test. There's a value test that if the work has artistic value or literary value, it's not obscene. But yes, there are obscenity laws. That was upheld by the Supreme Court by a 5-4 vote.
But we have it. Now, isn't Robin Byrd's show obscene?
Not even close. No, but everyone agrees it's not obscene.
Everyone agrees it's not obscene?
Absolutely. It's not obscene. If it were obscene, she wouldn't be on, precisely because there are obscenity laws.
So what is it, indecent?
In my view, no. But in Time Warner's view, it is indecent.
What's the difference? I'm trying to get the difference between the two.
The difference is that indecency, the definition that people are using, is something like patently offensive depictions of sexual or excretory activities or organs. So it has to be patently offensive, and it has to be a depiction or description of sex or excretion, you know. It doesn't have a value test. And that's the significant difference. Obscenity requires that it be without any value, artistic value, literary value, scientific value.
In other words, you don't have to ask yourself, I know it when I see it, which was the test that Potter Stewart...
That's never been a Supreme Court test.
Well,
that was his admission.
Sort of one way to talk about obscenity.
Yeah, but how many judges do you trust?
But anyway, it's not relevant.
To do that.
But let's say it is relevant for obscenity. It's not relevant for indecency.
It's the same silliness. Patently offensive depictions of sex. So if you have if you read from Philip Roth's novel, Sabbath Theater, I think it's called, won the NBA award last year as the best novel of the year. If that has explicit descriptions of sex acts and phone sex and other things like that, is that patently offensive? Who knows? Who will ever know? Will your show, if I started to read from Philip Roth's award-winning novel, could it go on your program? Would it be patently offensive? Could
Well,
it go?
that's the problem.
But isn't that ridiculous?
Yeah, but it may be ridiculous, but I mean that...
Well, we agree then.
Well, no, I agree. I agree that the whole issue of indecency is a very difficult issue, and that's why the Robin Byrd case is so important.
Right.
The concept is so elastic.
It's meaningless.
And
That's right.
broad.
It's censorship.
It's anything that's offensive.
It's
effectively.
anything a jury decides, a judge or jury decides after the fact was patently offensive to the relevant community, whatever that relevant community might be. In this case, it's probably cable viewers at midnight. And I assure you that what they're putting on, what Robin Byrd and Lou Maletta are putting on, is not patently offensive to cable viewers in New York City at midnight, because that's what they're watching.
But patently offensive has been held subject to regulation by the Supreme Court.
The
In other
words,
words, we've got two tests here, and this is a lesser
the words
evil.
have been upheld. Howard Stern has been fined repeatedly by the FCC for supposedly broadcasting indecency. We all are familiar with the famous 7 Dirty Words case, where George Carlin was, or the radio station was fined because they put on this George Carlin monologue, which used words, just dirty words.
7 dirty words.
7 dirty words.
So what's unconstitutional about this Helms statute? All it wants to do is to take Robin Byrd's programming, which
Right.
you can see now by going on to Channel 35 on 10 o'clock on Tuesdays and 12 o'clock on the rest of the week.
Right,
And the same with Lou Maletta,
right.
though I don't think Lou's on at 10, not that it makes any difference. And all the law says is that if Time Warner thinks that it is, quotes, indecent, I suppose using the definition that we've roughly referred to, it takes that programming, it scrambles it, and then you have to write in
Right.
to unscramble it. What's the big problem? They still get to show their...
It's the government. It's the government acting as super censor, as big brother, as saying this one category of speech as a governmental matter, as a matter of the police state. We're going to put special burdens and limit the audience on this one category of speech that is protected by the First Amendment. Everyone agrees that this thing called indecency is protected by the First Amendment. You can't make it a crime. And what the government is saying, because Jesse Helms decided he had an issue here he could get some mileage out of, is that he's going to try to censor. And make no mistake.
Why is it censoring?
Because
They
he
still
said
they still get to speak.
Did you
their
see?
lip isn't zipped.
Well, we'll just remove his audience. We'll just remove their audience, and we'll make it as hard as possible.
Anyone who wants to write in can get it.
Well, how about
Anyone who
they
wants
do
to
that
go
for
to the video-
C-SPAN?
Anyone who goes to the video store.
Suppose Congress passed a law that said any programming that's favorable to Republicans, we're going to scramble. No, right now the Republicans are in power.
Right.
So suppose that the current Congress passed a law, Jesse Helms,
Right.
Helms 2,
Right.
that said any programming that's sympathetic to the Democrats has to be scrambled.
Right.
Same case,
Well,
right?
You may think, or someone might think that's indecent speech, but it isn't.
But
But someone does think,
indecent
apparently,
is a-
that Robin Byrd's speech is indecent.
Jim, you just agreed with me that the concept of indecency is meaningless and ridiculous. That law, the Democratic, scramble the Democrats, is the same proposition as scramble Robin Byrd. And you would be the first one to say, no way, that's unconstitutional. That's a violation of the First Amendment.
But how about the cable operators' argument that we talked about when we first opened the show? Look, it's my speech, okay? I determine how the programming is coming on my channel. You know, I schedule the Knicks at 8 and the Rangers at 7:30, and I don't schedule them for 12. I mean, I decide how that's going to go on. And all I'm doing with this indecent speech is I'm deciding how it's going to be showed on my program. It's indecent, it's going to be scrambled. I could decide, would you admit I could decide to scramble the Knicks game if I wanted to?
You can air or not air whatever you have control over. I think you won't do that because you'll lose your audience, and they're out to satisfy their subscribers and to make the most money they can. They'll tell you that. Your question presupposes that access channels are the same as the rest of the channels. They're not. Access channels are for the other people. access channels are for the community. And you know, you're highlighting the programs that have adult themes and sexual themes, and that makes for lively debate and good television. But you know what's really on least access? Ethnic programs, religious programs, health debates, health programs. All of these programs are on only because of least access. They could not be on any other way. Do you think Time Warner is going to put on a talk show about women's health concerns or the Dominican programming? No. You need least access so that people who don't otherwise have a voice can have a voice.
But that's not really right, Ken. It's not that they have a voice because they have a voice. They can go out on the street and talk. They have a voice. They can make video cassettes, and you can go rent them and bring them home, hit your TV, it'll look just the same.
They just can't be on television. They just can't be on television,
really,
even though we've given this cable company a monopoly.
But what you really want is not for them to speak. You want them to speak to Time Warner's audience, which Time Warner's audience is created.
It's not Time Warner's audience. It's the television-watching audience of the city of New York. And Time Warner has the right or the ability to reach that audience because they went to the city of New York and said, please, 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 let us have a cable system.
Okay, now what's happened in your case? In the preceding show last week, we said that Mr. Maletta and Ms. Byrd were so effective, but we were really talking about you. They won. They beat Time Warner. And meanwhile, back at the Supreme Court, a companion case, in effect, a peer case, is going up that's deciding the same issue that is going on in your case. Where does your case stand?
Well, our case, which raises somewhat different issues than the so-called alliance case, our case is being held in abeyance. We won at the trial court level. We got the injunction that stopped Time Warner from scrambling. And then the Supreme Court agreed to hear this challenge to the Helms Amendment, the constitutional challenge to the Helms Amendment. And so the parties, and Time Warner especially, agreed, well, we'll defer and delay our appeal from our scrambling case until the Supreme Court decides
what do you think
the
the Supreme Court's going to do?
Well, I was at the argument.
You were at the argument?
I watched the argument.
We should say the Supreme Court may have already done it by the time you
well,
watch
it may have, although I think most people anticipate that the decision will come down probably in June, that based on the questions and the skepticism that a lot of the justices
Why were they
raised.
skeptical?
Well, for perfectly obvious reasons. The Helms Amendment is silly. The Helms Amendment is very hard to defend for one reason, among others. It only addresses indecency on the access program. While everybody knows there's lots of other indecency.
But I heard you say that before, but it's not the same.
It's exactly the same.
The other...
only Time Warner makes $5 a pop on it.
But really, as much as we want to be courteous to our guests of last week, Robin Byrd and Lou Maletta, the other programs on Time Warner aren't like those programs.
Jim, you haven't watched it. Jim, trust me on this one.
I haven't watched what?
They have porn movies on. Time Warner is a purveyor of pornography. They admit it. Only they charge a pay-per-view of $5 a viewing for a two-hour movie. They have pornography, and they're going to continue to have pornography. It is every bit as explicit, every bit as nude as anything that Byrd and Maletta and Goldstein put on.
So,
only they're charging $5 a viewing for it.
So, but basically, your argument is that the statute in constitutional lawyers' terms just so overbroad and sweeping that there is no way that the Supreme Court will uphold it?
Yeah, I mean, in constitutional terms, it uses the phraseology of indecency. Indecency is protected speech. It is not illegal. It is legal speech. So the government cannot censor protected speech. The last time the Supreme Court...
I still don't see how they're censoring it.
They are saying, they're passing a law.
They're just saying it's being channeled.
They're passing a law that says this speech only can be and must be scrambled. All other speech need not be, and indeed cannot be scrambled on access. Only this small category of legal speech must be scrambled. It's the first time the government has tried to, you don't think scrambling is censorship, then we disagree on that. But everyone seems to agree that if this is so-called state action, which is if this is action by the government, it's unconstitutional. The legal issue was whether the Helms Amendment bypassed the governmental role. And that's a technical legal argument.
Well, what do you think the court, do you have any idea what the votes will be on the court from the questions that you heard?
Well, some justices were not especially, did not indicate sympathy.
Who were that?
Predictably, Justice Scalia and Chief Justice Rehnquist.
Rehnquist and Scalia were not?
Where
was Justice Thomas on this?
Justice Thomas is always silent at Supreme Court arguments. He never asks questions, so he does not give you any indication of what concerns him, what he's thinking about. I think all of the other justices, Ginsburg and Souter and Kennedy and Stevens and Breyer, and I'm probably leaving, did I say O'Connor and Ginsburg, they all asked questions. And they all asked questions which conveyed the impression that there were parts of this law that bothered them, that didn't hang together, that didn't make a lot of sense. You don't always learn how they're going to vote by listening to their questions. But listening to the questions at least tells you that they're having problems with this law.
So you think, hope you're not embarrassed when this program shows
it won't be the first
after the decision that the court's going to overturn the Helms Amendment. Do you think other efforts will follow to regulate Robin Byrd's speech and Lou Maletta's speech on the theory that it's indecent?
It's a sad fact today that cracking down on so-called indecency is politically popular. You lose no votes by looking tough on sex and tough on indecency. So as long as there's an opportunity, politicians will try to take that opportunity. There is this phenomenon called dial-a-porn, which is the use of telephone sex lines. And Congress has tried, pretty much unsuccessfully, but they've tried to clamp down on that.
We've got to come to it. And I want to thank Ken Norwick very much for coming in and defending Robin Byrd and Lou Maletta and telling us what he thinks about the Helms Amendment. He thinks it's unconstitutional, and perhaps the Supreme Court will come to that decision too. Thank you very much.
Thank you, Jim.